This is part 6 and the conclusion to civil procedures, beginning with the right to a jury trial. This is found in the 7th Amendment. This is action at law. You have a right to a jury trial. This is where there are damages. This is tried on demand to a jury. You must demand the jury trial. You have no right to a jury trial for an action in equity. This is where you're seeking an injunction. If the action before the court is both a mixture of damages and injunction, meaning a law and equity action, the jury will first hear the action at law for damages, and the judge will hear the second in equity, the action in equity for the injunction. The jury, looking at the jury size, it may not be less than 6 members, cannot be more than 12. Types of verdicts. A verdict must be unanimous unless it is stipulated to otherwise. Again, these are the federal rules. Again, at a special verdict, this is where the jury determines, then submits the facts to the judge who applies the law. So the jury will determine the facts, submit those facts to the judge. Judge then applies the law. You have a general verdict. This is simply a verdict in favor of the plaintiff or the defendant. A judgment as a matter of law. This may be made on a motion at any time before the case goes to the jury. This is where there is insufficient evidence for the jury to determine the action. The motion, judgment as a matter of law, is reviewed in light most favorable and or reasonable inference is drawn in favor of the opposing party. That's the standard in generally all motions. Looking at an appeal of an action, appeal must be made within 30 days of the judgment and or order. To appeal, the final judgment rule applies. A decision by the court, it's only appealable if there is a final judgment. That's the final judgment rule. This is a decision by the court on the merits that leaves nothing for the court to do but execute the judgment. Denial of a summary judgment motion or a motion to dismiss is not immediately appealable. Certain equitable orders regarding injunctions and or appointment of a receiver and admiralty cases are immediately appealable. Mandamus review. Mandamus review may be used to immediately review an order that is an abuse of authority. However, mandamus review may not be used on all errors that constitute an error of law. Mandamus review is for an abuse of authority. And standards for reversal. We have factual findings. This is the clearly erroneous standard. This leaves the appellate court with a definite and firm conviction that the trial court made a mistake. And that's again in regards to factual findings. In regards to legal rulings, this is de novo review. There's no deference to the trial court's rulings. Factual findings, deference. Legal rulings, no deference. Full faith and credit, we've discussed this in other sections. A judgment properly entered in one jurisdiction or state must receive the same effect in other states and jurisdictions as in the state where it was rendered. Claim preclusion, res judicata. This is after judgment. You may not sue twice on the same claim in a subsequent action. Issue preclusion. This is collateral estoppel. This precludes relitigation of issues of fact and or law determined in an earlier claim. Now, issues against whom it is to be precluded, however, must have been a party to the original action. And that completes all of civil procedures.